This is Lynch of Lynch Solicitors. This is our second COVID-19 presentation, and we're doing it on a topic that we've got quite a number of questions about, which is, it's called, legally the term is adverse possession, but commonly it's called squatter's title. It can happen quite commonly in the case where, for example, a piece of property is owned by someone who dies and none of the legal formalities. Therefore, for example, I own a piece of property, I leave a will, or I don't leave a will, and my children or my family do nothing about correcting or sorting the title. In these circumstances, if there's a will enters on the property or goes and lives in the house, let's say it's a house, goes and lives in the house, and is there for a period of 12 years, the question that is often asked is, does that person acquire rights or own the house after the 12-year period? Another situation that's quite common is, for example, somebody owns property or owns, let's say, a strip of land, and somebody else starts to work on land, starts to put cattle on the land, starts to use it as if it is owned by them and not by the person who is, as we say, the paper title owner. In other words, the person who, by law, if you check the register or the title documents, you see that they are the owners of the property. Another situation, again, another example of what you'll often see, is where you have, for example, a housing estate, and you have a small strip of ground, let's say at the end of a block of houses, a green area, and somebody fences off that green area and starts to, let's say, just for the sake of argument, puts in flowers, puts in grass, cuts the grass, and literally just looks after it for a period of 12 years. So those are three circumstances where the question can be asked, well, who owns it? And this is where squatter's title or adverse possession comes into play. Now, there's been a number of cases on this particular topic, as you can very well imagine. One of the most recent cases involved, well, there were actually two examples I can give you of recent cases. One case involved CIE with a bit of ground at the side of the station where somebody had been going in at regular intervals, putting in cattle, putting in a horse, having a shed there, coming in and out of the property for long over 12 years. I keep mentioning the term 12 years. It can be 12 years, 13 years, 14 years, for as long as you like. The reason that I'm referring to 12 years is that the very first thing that you can say is that if you're not in exclusive possession of the land for more than 12 years, you can't acquire any interest in the land. So the very first rule of thumb is there is a time within which you must have been in possession in order to argue that you've acquired possession or that you now own the property or the land involved. The CIE case that I was talking about, in that particular case, the second part of the limb is that obviously there's an assumption, not obviously, but there is an assumption at law that the person who is on the title documents, on the folio, the person, as I call the paper owner, by definition, they own the property. And if you go into a court of law, the court of law will assume that they are the owners. So that's your starting point. The next point from the squatter's perspective is that this squatter must prove that they own it. And to do that, they have to prove two kind of fundamental things. Number one, well, there's more than two, but two from their perspective. Number one, that they are in exclusive possession in the land or were in exclusive possession of the land for 12 years, and that they intended to acquire it. In other words, they intended to take over ownership of the land. So if we go back to the CIE case, in the CIE case, the other criteria kicked in. So there was an assumption that CIE owned it, number one. Number two, there was proof introduced by the squatter that they actually had used it for a period of 12 years. And the next kicked in, or the next element to the part of the jigsaw then came into play, and that was whether or not there was exclusive occupation by the squatter for a 12-year period. And that's where the case by the squatter fell down. And it fell down for the very simple reason that the courts, while they, number one, assume that the paper owner is the owner, and number two, require proof by the squatter that they had exclusive possession and intended to take over the land, the third part of the jigsaw is that any act, no matter how small, by the paper owner will displace the argument or negate the argument being put forward by the squatter. And in the CIE case, the piece of evidence that CIE were able to show was they had actually cut the hedges, they had gone in at regular intervals to inspect the lands, and that these were all indications that there wasn't exclusive possession by the squatter. There was another case which I can give you an example of, which involved a dwelling house which was bought and purchased by new owners. And when they literally went to check the house, physically went into the house, they found somebody living in the house. And that somebody made the argument that they were squatters. And in that case, number one, the assumption was that the people who bought the house owned it. That was the first assumption. Number two, the squatter put in evidence that they had actually lived in the house for more than 12 years. And in those circumstances, argued that they had acquired title over that period of 12 years. However, the stumbling block from the point of view of the squatter was that the owners were able to, the paper owners that is, were able to introduce evidence to the effect that in fact they, or their predecessors in title, in other words, people from whom they had bought the property, that they had actually insured this property. And not only had they insured it, but they also had come in and carried out repairs on the property. So in those circumstances, the threefold test fell down on the third limb, if you want to put it that way. In other words, the assumption was that the paper owner owned it. However, the squatter did prove that they were in possession. However, they did not prove that they were in exclusive possession of the property. The final point that I'd like to make on it, and this is a very broad topic, but the final point that I would like to make on it is that once you lose it, you lose it. And what I mean by that is that if a squatter takes exclusive possession of a bit of property, a bit of ground, a bit of land, or a house for over 12 years without any act by the paper owner to prove that they in fact were exercising control of this or physical control of the land, in those circumstances, then if you're out, you're out. So if the 12 years runs, it doesn't matter what you do after the 12 years. So in other words, if you suddenly realized after, say, 10 years that someone was squatting on your land, you can't do anything about it if in fact over that 12-year period you did nothing to show, even by way of minimal act, insured it, went in and inspected it, repaired it, or whatever. If you did nothing for that 12-year period, then the squatter acquires title to the property. I hope you found this video informative. My name is John Lynch of Lynch Solicitors. You can find us on our website, which is lynchsolicitors.ie. We're also on Facebook and Twitter. And of course, you can contact us at our offices in Clonmel, County Tipperary, 052 61 24344. Thank you very much for listening to me, and I hope you found this informative.